Hello everyone, and welcome to the third webinar in our series. My name is Anuth Nashan, Project Manager of Courage to Act. Courage to Act is a 2-year national initiative to address and prevent gender-based violence on post-secondary campuses in Canada. It builds on the key recommendations within Possibility Seed's vital report, Courage to Act, developing a national framework to prevent and address gender-based violence at post-secondary institutions. Our project is the first national collaborative of its kind to bring together experts and advocates from across Canada to end gender-based violence on campus. A key feature of our project is our free webinar series, where we invite leading experts to discuss key concepts and share promising practices on ending gender-based violence on campus. Supported by Caucus, these webinars are also a recognized learning opportunity. Attendance at 10 or more live webinars will count towards an online certificate. Our project is made possible through generous support and funding for the Department for Women and Gender Equality, WAGE, Federal Government of Canada. We begin today's webinar by acknowledging that this work is taking place on and across the traditional territories of many Indigenous nations. We recognize that gender-based violence is one form of violence caused by colonization to marginalize and dispossess Indigenous peoples from their lands and waters. Our project strives to honor this truth as we work towards decolonizing this work and actualizing justice for missing and murdered Indigenous women across the country. I want to pause now and invite everyone to take a deep breath. This work can be challenging and this topic hard. Many of us have our own experience of survivorship and of supporting those we love and care about who have experienced gender-based violence. A gentle reminder here to be attentive to our own well-being as we engage these hard conversations. So before I introduce our speakers today, a brief note on the format. Karen and Joanna will speak for 40 minutes, and I invite you to enter questions and comments into the question and answer box, and I will monitor this. And together we will pose these questions to Karen and Joanna at the end of the presentation. This will happen in the last 15 minutes. At the end of the webinar, you will find a link to the evaluation form. We'd be grateful if you take a few minutes to share your feedback as it helps us improve. This is anonymous. Following the webinar, I will also email you with a copy of the evaluation form, details on how you can purchase a new book, and link to the recording so you can review the webinar and share with your networks. And now, I'd like to introduce our speakers today. Karen Busby has been a law professor at the University of Manitoba for more than 30 years. One focus of her teaching, research, and advocacy work is gender-based violence. Most recently, together with Joanna Birenbaum, she has written a book titled Achieving Fairness, a guide to campus sexual violence complaints, which Thomson Reuters published in March 2020. Another of her current research projects is an empirical study on the reasons for attrition in criminal sexual assault cases. She's on the University of Manitoba committee charged with reviewing that institution's response to campus sexual violence. Karen has worked with various community and professional groups on numerous law reform projects and case interventions related to gender-based violence, queer issues, and assisted human reproduction. This work has garnered numerous awards, including the YWYMCA Woman of Distinction Award, the Canadian Bar Association Hero Award, and the Lambda Community Changer Award. She is also a recipient of the University of Manitoba's highest teaching honor, the Saunderson Award for Excellence in Teaching. Joanna Birenbaum is a litigator in Toronto with expertise in gender equality and sexual violence. Her extensive experience in this area includes constitutional litigation, civil sexual assault claims, employment law, human rights, and workplace investigations, representing complainants in sexual history applications in criminal sexual assault proceedings, and defending malicious prosecution and defamation claims targeting women who have reported sexual violence. Joanna's recent Supreme Court of Canada appellate advocacy in these areas includes Platnick v. Bent, 2019, and R v. Quesnel, 2014. Joanna prosecutes for a regulated health college in Ontario, including cases involving allegations of sexual abuse. Joanna also advises institutions and employers on sexual violence policies and procedures. Joanna was a 2014-2015 McMurray Fellow at Osgoode Hall Law School and adjunct faculty at Osgoode, 2014-2017, teaching in the areas of gender equality in the law and violence against women. In addition to a private practice, Joanna is also the Director of Capacity Building for the Canadian Legal Centre for Legal Innovation in Sexual Assault Law Response. It is my pleasure now to turn it over to Karen and Joanna.
Thank you very much, Anuth, for that kind introduction. And Joanna and I would really like to thank Courage to Act, especially Anuth and also Farah Khan for organizing this seminar today. I should also acknowledge the work of one of my funders, the Social Sciences and Humanities Research Council of Canada. And I'd also like to do a territorial acknowledgement. I'm in downtown Winnipeg, so I'm on Treaty 1 territory, and I'm very close to the forks of the Red and the Assiniboine River, which is a historic meeting place for the Dakota, Dene, Cree, and Anishinaabe peoples, as well as the Métis people. Now, as Anuth mentioned, Joanna and I have just published a book, and I mentioned the book now for two reasons. Can you advance the slide, please, Anuth? I mentioned the book for two reasons. One, of course, is to promote it, and some information on how you can order the book will be sent to you after the session today. But the other reason why I mention it is because one of the methodologies we use in this book is to compare and contrast the sexual violence policies in force at 25 post-secondary institutions across the country. And in the presentation, we will often refer to provisions as being in some, many, none, most, and so on of the policies. And when we do this kind of comparison, we're talking about the 25 policies that we reviewed in the book. Obviously, we didn't review every sexual violence policy in the country, but we took kind of a representative sample. So first of all, what is an interim measure? An interim measure is a decision to restrict interaction between respondents and complainants. And this is done through actually restricting interaction through, say, a non-contact order, restricting a respondent's presence on campus, or restricting a respondent's proximity to a complainant. So that can include campus bans, for example. So we like to think of interim measures decisions as about interaction, presence, and proximity. And why is there a need for a primer on interim measures? Well, in our view, one of the most challenging decisions that may need to be made in the course of a campus sexual violence complaint is whether to impose interim measures on respondents. Only the determination on whether a policy has been breached is a more difficult decision to make. Now, we know, at least anecdotally, that the main reason some, perhaps many, complainants make a formal complaint is that they find themselves in the untenable situation of ongoing contact with the respondents. The complainant's immediate needs are to continue their education, their residence situation, or their employment in a manner that feels safe and supported. For these complainants, calling the respondent to account is very much a secondary consideration. What they want to do is manage ongoing contact. So not only is the decision a difficult one to make, it's one that the decision maker must make quickly, and often without much information. So our objective today is to suggest some ways to ensure that interim measures decisions are fair to respondents and complainants. Now, I want to mention three challenges in doing work on interim measures. The first one is that our policy review revealed a startling lack of detail in policies and related guidance documents on the matters we're talking about today. Very few documents, for example, set out objectives, set out the standard to be met, and so on. Particularly concerning in most policies is the total absence of any detail on procedural rights. So of the 25 policies reviewed, not a single one gave respondents a right to be heard before a decision is made, and only a few expressly stated that a complainant had the right to be heard before a decision was made. So we found that very surprising. Secondly, there aren't really reliable risk assessment tools available. Some people are trying to develop them, but to date, there isn't kind of a checklist of things that you can look at a decision maker can look at to try to figure out whether or not an interim measure is warranted in a particular case. And the third overarching challenge is there's almost no case law on the fairness of measures imposed, either substantively or procedurally. In fact, there's only one case on interim measures, and Joanna's going to talk about that case for a few minutes right now.
Hello, everyone. Thank you again to Courage to Act for including me in this presentation. So as Karen mentioned, there is very little case law on interim measures. And we thought that both for this reason, but also because it's helpful for the rest of our discussion, we'd spend a bit of time telling you about the one case that there is, which is an Ontario labor arbitration decision from 2018 involving Ryerson University. Briefly, the facts of that case are that sometime early in 2018, a complaint was made against a faculty member by a former graduate student. The allegations were that over a 3-year period, approximately between 2007 and 2010, the professor sexually harassed that student, including by drinking with her and other students, flirting with her, putting his arm around her, and generally directing unwanted attention toward her. There was also an allegation that in April of 2010, the professor went to the student's apartment, made a sexual advance towards her when he was alone with her in her apartment, and then left after the advance was rejected. Now, what's important for the purposes of this webinar is that following receipt of the complaint by Ryerson, interim measures were almost immediately imposed on that professor, the most serious of which were that he was banned from campus and he was prohibited from any unsupervised contact with students. He did continue to receive his full pay, but practically he couldn't teach his scheduled courses or fulfill various other of his duties. Not surprisingly, the Faculty Association, his union, grieved the interim measures, arguing, among other things, that they were unduly harsh, particularly given that the complaint involved allegations that were almost 8 years old, or even longer, and were made by someone who was not a current student or employee. So the types of concerns that Karen mentioned in the introduction about imposing interim measures in order to prevent contact with a respondent and complainant were not front and center in the Ryerson case. The arbitrator upheld the interim measures, including the most stringent ones. We'll discuss a bit later in this webinar the importance of institutional policies making clear what standard interim measures must meet. In the case of Ryerson, the arbitrator held that the employer had a duty to meet the legal test of the interim measure being reasonable and justifiable. The arbitrator held that the interim measures in that case were justified to protect the reputation of Ryerson in responding rigorously and seriously to reports of sexual violence. In terms of one of the objectives of interim measures being protecting safety, another important aspect of this decision is that the arbitrator held that the consideration of safety must be broadly understood and is not narrowly limited to the safety of the individual student. Rather, interim measures can be justified, and were justified in that case, because Ryerson had an obligation as an institution to ensure that Ryerson community members more broadly felt safe, including in the sense that they had faith and trust that their institution will take appropriate measures in response to reports of sexual violence. So keep these facts in mind as we move to some of the later slides in this presentation about the considerations for institutions, complainants, and respondents when interim measures are proposed or being thought of being proposed. So now I'm going to turn to some nuts and bolts. First and foremost, who is the decision maker? Who is it within each institution that decides whether an interim measure is to be imposed and how? Now, many policies that Karen and I reviewed had quite a broad definition of who that decision maker might be, and could include any one of a program head, a dean, a department head, central administration, registrar for students, among a number of possibilities. Now, the idea that a range of people could fulfill the role of decision maker is often attractive to institutions because it allows institutional flexibility, but the downside to that is that it's uncertain. And it means that it can be challenging, not just for complainants and respondents, but also those within the institution who are either frontline responders or administrators, to know in each individual case who that decision maker is. So if you are attending as a representative from an institution, it's important that you try to get ahead of this problem and be able to figure out who within the institution, depending on who the complainant or respondent is that decision maker, so that you can provide clear and quick information to respondents and complainants. And before I move from this slide, at some institutions, interim measures are imposed in consultation with some form of team, like a sexual violence response team that can be made up of institutional actors like the sexual violence response officer, counselor, sometimes campus security, which may lend itself to an interdisciplinary approach. And one of the great things about the work that Courage to Act is doing is to look at some evidence base as to what the best structures are for making these decisions. The next question, if you move to the next slide, Anoop, is what are the competencies of the decision makers in the context of interim measures? A core competency, particularly given that many policies now commit themselves to a survivor-centered approach or language that meets those same concerns and objectives. So a core competency is that the decision maker be trained in and be competent in a trauma-informed approach to the complainant. This means having the ability and competence to hear from and understand the complainant's needs in an open and non-judgmental manner. So one of the questions institutions should be asking themselves is what training has been provided to decision makers on sexual violence and trauma-informed approaches, and how often that training should be revisited and repeated. Handing it over to Karen.
Okay, I'm going to talk now about what are the objectives of interim measures orders. The first thing that needs to be noted about objectives is that they are not intended to be punitive, rather they are precautionary. They're intended to ensure that there is no further harm and that a complainant feels safe in circumstances. And yet policies are not always clear on this point. So we really recommend that, a statement about the precautionary nature of interim measures be included in all policies. The danger if it's not included is that the interim measures decision could become to be seen as a preliminary finding of a policy breach, and that's not fair in these circumstances. But the reality is that most of the time, objectives of interim measures are often unstated or are limited to kind of a narrow conception of complainant's personal safety. Not all institutions do this. University of Alberta, for example, has a much more expansive approach than just personal safety. So it, for example, you can change the slide. It, for example, lists a number of other objectives. So, for example, an interim measure can be issued to discourage or prevent retaliation. It can be issued in order to prevent sexual violence in the event that there is evidence of, for example, serial perpetration by a respondent. It can help to protect confidentiality. From a complainant's perspective, it can minimize disruption to the learning, working, or residence environment, and also take into account ways in which you can minimize disruption for the respondent as well. And finally, sometimes interim measures are necessary in order to preserve an institution's ability to conduct a thorough investigation. So you can see that the objectives of interim measures can go far beyond just a narrow consideration of what are the safety needs, the personal safety needs of a complainant. Back to Joanna.
The next question we wanted to address is who initiates interim measures. Usually the complainant requests interim measures, but it's important to remember that it's not uncommon for a complainant to be in a state of crisis at the point that she makes the decision to disclose or report to the institution. And a common source of frustration for complainants is that the burden is sometimes or often on their shoulders to know what to ask for in terms of interim measures. At some institutions, the sexual violence officer does proactively provide the complainant with a range of options that she might be able to request without, of course, guaranteeing that the request will be granted. But this proactive step is important because it's not fair and generally not consistent with the trauma-informed approach to simply ask the complainant in an open-ended way, so what do you want? It's also important to remember that institutions generally also have the ability to impose interim measures at their own initiative, and so it doesn't have to fall on the shoulders of the complainant to make the request. What we've seen to date, that most commonly institutions will impose interim measures in certain sets of cases. For example, if the respondent is a faculty member, like in the Ryerson case, or where there's a pattern of behavior, there's evidence known to the institution of prior conduct on the part of the respondent, or sometimes where the seriousness of the conduct or the public nature of it demands the institution to respond at its own initiative. So for example, if there's drugging or strangulation to overcome resistance, or where there's a videotape of the assault. And just to point out how different some policies across the countries can be, unique among the policies that Karen and I reviewed is the Université de Montréal policy, which requires the imposition of interim measures on respondents must be agreed to by complainants. And that's comparatively a unique provision. So the next question is, when can interim measures be imposed? And this is a really good and important question because of the distinction between a disclosure and a formal report. And I think probably most participants in this webinar are familiar with that distinction, but just in case, a disclosure under most institutional policies now is intended to allow the complainant to disclose or reveal her experience and seek support and accommodation from the institution without triggering any formal response automatically and without there being notice to the respondent. Whereas a formal report is a process in which the complainant discloses, in the sense of reveals, explains the experience that she's had, but with the expectation that the university will respond, including by possibly disciplinary measures on the respondent. Now, interim measures cannot be imposed on a respondent unless he's given some information, right? Interim measures can't be imposed on a respondent unless he knows what the allegations are that gave rise to the interim measure and who made those allegations. And it's probably for this reason that many policies provide that interim measures can only be imposed following a formal report being made and not a disclosure. But what Karen and I notice is possibly an emerging idea or practice where interim measures may be imposed following a disclosure, provided the complainant consents to her name and the details of the allegation being disclosed or provided to the respondent. And one really significant advantage of that is, as Karen said at the outset of this webinar, that for some complainants, what they really want is immediate needs met. They want him out of their class or out of their residence. They want to be able to continue with their schooling and complete their degree without having to fear coming into contact with the respondent or otherwise have protection around reprisals. And for some complainants, that addressing those needs may be the entirety of what they need. And for some complainants, they don't actually want to see a disciplinary response meted out on the respondent. So allowing interim measures to be imposed following a disclosure, obviously only with the consent of the complainant, has potentially some real opportunities for complainants in terms of meeting immediate needs without then imposing the real stress, emotional toll, distraction, and time that's involved, not just for respondents, but of complainants in being engaged in formal reporting processes. We wanted next to turn to the range of standards for imposing interim measures. And this was the issue that I flagged when discussing the Ryerson Faculty Association case, that there are different standards that different policies may delineate for which the institution must meet when imposing an interim measure. Some policies are silent on what the standard is. Other policies use very different language. So some policies may use the language of minimally impairing the respondent's rights. Other policies may use the language of the measure must be appropriate in the circumstances, or appropriate and proportionate in the circumstances, or, for example, reasonably and necessary to ensure safety. And then the question will be, what does safety mean? Is it narrowly construed? Is it broadly construed? But what Karen and I wanted to do here was just to flag for you that the standard is a critically important issue when imposing interim measures and when developing these policies, and that these various words are not interchangeable. A standard of minimally impairing a respondent's rights is a very different standard than appropriate and proportionate or reasonable and justified. And with that in mind, we wanted to specifically address the disadvantages of a standard of minimal impairment. The standard of minimal impairment unduly narrows and constrains institutions. The standard would appear to exclude, or at least very significantly underplay, consideration of the complainant's rights and needs. For example, her human rights and needs to access education or work or living accommodations at the institutions. Minimal impairment of the interests and activities of the respondent is certainly one consideration among many in imposing interim measures, but it is not and should not be the exclusive or primary consideration. Other significant considerations for decision makers when imposing interim measures, and this ought to be reflected or built into the standard, is the integrity of any ongoing investigation, and as discussed in the Ryerson case, the ability to protect and perpetuate a culture on campus in which this kind of behavior is not tolerated and community members broadly feel safe and feel trust in their institution. So to conclude on the question of the standard for interim measures, in the view of at least Karen and I, as well as the arbitrator in the Faculty Association case, the language of appropriate and proportionate, or fair and reasonable, justified, are rigorous enough to protect both complainants and respondents' rights and ensure that institutions have the flexibility and are able to consider and balance these multiple concerns without explicitly requiring a more narrow and constrained focus only on minimally impairing measures as they might affect the respondent.
Okay, I'm going to look at the question now of procedural fairness. But before I do that, I want to answer one question that's come up in the Q&A or in the chat. And that is a question of whether or not our survey was only of university policies, or whether or not it included CEGEPs and colleges and institutes. And we did include colleges, 2 colleges and institutes, and 1 CEGEP in our policy review. So it's mostly universities, but we did make an effort. So Sheraton College and Southern Alberta Institute of Technology's policies are included in our survey. Now, at the beginning, I noted that a small number of policies require or suggest that decision makers should solicit complainants about their thoughts on interim measures. And as Joanna noted, one of the policies we reviewed, Université de Montréal, expressly requires that complainants consent to interim measures before those measures can be imposed. But I also noted, and this was really surprising to me, that none of the policies we reviewed expressly acknowledges that respondents have to be heard on the question of whether to impose interim measures, and if so, what those measures might be. We found this observation really troubling. So let's look at the question of what procedural rights should respondents and complainants have. And we decided to deal with these 2 rights together because our view is that the procedural rights for respondents and complainants should not really be that much different. So in other words, in the face of silence in a policy, what procedural rights should a decision maker read into the policy? A most basic principle of procedural fairness is that those who might be affected by the decision have the right to know that a decision is being made. So this is the right to notice. They have the right to know the case against them, and they have the right to an adequate opportunity to respond to the case. And these rights are often shorthanded as the right to a hearing. So let me just repeat that again. They have the right to know that a decision is being made, the right to know the case against them, and the right to an adequate opportunity to respond to the case. Now, most policies state that they will take a trauma-informed approach, and so at a minimum, in our view, in the context of interim measures, is a requirement that a complainant must be consulted and ideally should have some measure of control over interim measures that might be issued. So if she doesn't want them, then they shouldn't be issued unless there are strong countervailing considerations. In most cases, complainants and respondents should have the right to notice. And what this means is that they should have the right to know that a decision is being contemplated around interim measures. Now, the right to notice doesn't have to be fancy. It doesn't have to be served in person. It can be given orally. It can be given electronically. We would suggest email or some kind of text-based format because it makes proof of notice easier if it's later alleged that there was no notice. But in our view, both respondents and complainants, unless there's a real emergency situation, where like a respondent needs to be immediately moved out of the same residence where he lives together with the complainant, there should be a right to notice that a decision is being made. As far as the right to be heard goes, people often conflate the right to be heard with the right to an oral adversarial hearing, and that's not what we're suggesting here. There is no right to, there's no need for an oral adversarial hearing at this preliminary stage. Rather, the right to be heard in this context simply requires that an affected party should have the ability to present information and argument to the decision maker in a manner that is attentive to the context. So in the context of interim measures, the issues are simply where the issues are what measures are needed and should they be imposed. The right to be heard could be satisfied through a series of telephone calls between the decision maker, the respondents, and the complainants as to what measures are just and appropriate in the circumstances. We have little doubt that respondents or complainants who were denied any hearing rights before an interim decision maker would be successful in having that decision overturned were there to be a judicial review application unless there was a real emergency. So we think that the failure to have hearing rights and the failure to give hearing rights is a recipe for or an invitation to an application for a judicial review. Briefly, we want to talk about the right to reasons. Case law in Canada supports the view that decision makers are required to give reasons for decision in most administrative matters, but in particular, what we're talking about here is the decision to impose interim measures. And the reasons for this are twofold. One is to engender support for a decision. So if people know why a decision was made in a particular way, they're more likely to support it. And also to facilitate judicial review. So judges can't review decisions unless they know something about the basis for the decision being made. So those are a few reasons why reasons for decision are in our view required with interim measures decisions. The other thing that's important about reasons for decision is it's critical to ensure that respondents as well as complainants understand all aspects in terms of orders or decisions and the reasons, and in cases where an interim order wasn't issued, the reasons why it wasn't issued. So the reasons ensure that respondents and complainants get proper notice of what measures would or have been put in place. Finally, reasons for decision should also set out what the consequences of breach are and what the duration of the interim measures order is. So most interim measures orders would expire once a final decision has been made by an institution, but it's possible that the duration could be different. So they should set out, as I said, the consequences of breach and the duration of the order. what happens if there's a failure of procedural fairness? Well, the consequences can be significant. The most important one probably is it weakens the ability of the decision maker to make a well-informed decision. If you talk to both of the parties, for example, you might find a solution that the decision maker would never have contemplated on their own. So an example I always like to give is the decision maker might say that the complainant can use the gym on Monday, Wednesday, and Fridays, and the respondent can use the gym on Tuesdays, Thursdays, and Saturdays. And this might be perfectly satisfactory to the parties, and it meets the needs of both parties. So by living up to procedural fairness, so the right to a hearing, the right to notice, and the right to reasons, you're going to get better decisions that are being made. Secondly, the failure to live up to procedural fairness may compromise the complainant's safety. And the third thing, of course, is the failure to live up to procedural fairness is an invitation to a challenge in court by the respondent for failure to provide procedural fairness. Joanna? Next slide.
Yeah, the next slide is what information do decision makers need. But in answering that, I wanted to start by addressing one of the questions that was raised on the chat, which is, I'll just read it, which is, are there any downsides to framing complainant needs entirely through a trauma-informed approach? Should we not also be considering complainant needs as a matter of human rights? And in case I realized this wasn't clear, that our book, and both Karen and I do situate the analysis of all of these policies and procedures, anchoring them in respecting the human rights of complainants. And that's part of the reason why the discussion that Karen just had, complainants have effectively the same procedural rights as respondents, because if they have experienced sexual violence and that experience interferes with their ability to access their education or their workplace at the institution just doesn't, as a matter of goodwill or PR, have an obligation to respond to their complaints seriously, but they have a legal obligation under human rights statutes across the country to respond to and meet the allegations that have been made in a non-discriminatory way. So when Karen and I have talked about, first and foremost, in response to a disclosure or a report of sexual violence, an interim measure needing to consider her needs and circumstances in continuing to access education or work or her residence or other activities on campus. What we mean by that is through a human rights approach and a human rights standard, her right to access education. Yes, that also needs to be intertwined with or intersected with a trauma-informed approach to meeting those needs, but it is fundamentally anchored in the complainant's human rights, quasi-constitutional human rights. And then those rights will need to be balanced on a case-by-case basis, both in terms of procedural fairness and substantively with the rights of the respondent when considering interim measures. But that does lead directly to the question of what information do decision makers need, because there is a range of information that decision makers should strive to have before them when considering interim measures. And the first that we've put on the list is information from the complainant about her needs and well-being. And again, we mean that not just from a trauma-informed perspective, but from a perspective of her rights to continue, not to drop out of school or quit her job or leave her residence, but her right, her legal right to continue accessing education, work, and whether it's residence or other activities on campus. Secondly, as we've mentioned, some institutions may have risk assessment tools or ones that are being developed, and those may be available for decision makers. In some cases, there may be a pattern of behavior known involving the respondent. Sometimes that can be tricky if there's a pattern of behavior known because there's a disclosure, but the notice hasn't been given to the respondent, so he's not aware that the institution has information about a pattern of behavior. And certainly not just as a matter of the respondent, ought to because he should, but there should be a requirement that the respondent advise his institution whether there have been criminal charges and whether there's any court order restricting his movements. And less commonly, those could also be a family court order if there's a restraining order. Now, it is acknowledged that intermeasure decisions are often made at an early stage. So the institution may not have all possible evidence before it, but that's the reality of making these decisions. And institutions need to simply make the best decision they can with the evidence before them. And a subsequent question that we were asked on the chat relates to, well, what about appeals or seeking to review intermeasures? So intermeasures, and we'll get to this in a moment, ought to be amenable to change, including change because of new circumstances or new evidence that's available to the decision makers.
Okay, I'm going to turn and look at the question of choice of measures, and I can see that we're at 40 minutes. So I think we've got another 5 minutes or so before we turn to question and answer. So I'll try to be quick, although I promised Joanna I would not speak quickly today. That's a characteristic of mine that's sometimes less than endearing. So we have to remember that post-secondary institutions are places of work, study, leisure, and living. So intermeasures can have significant impacts. And one of the important things to remember is that these orders need to be custom crafted to suit the situation and the individuals involved. So you can't rely on boilerplate, you can't rely on standard clauses. You really have to think about what is the situation and what do the individuals involved need. And so sometimes there will be prohibitions on interactions or restrictions on interactions. And here you might see, for example, a non-contact order or types of permissible interaction. So for example, if the parties have classes together, then there might be permissible classroom interaction, but any kind of interaction outside the classroom might be prohibited. You can also see presence limitations. So there might be limitations on a respondent's attendance on campus. So they might be temporal limitations, like the example I gave earlier of the gym. Or there might be orders to stay away from places that the complainant frequents, such as her residence or her place of work if she is employed on campus. And then there might be proximity restrictions. So, outside of class, you cannot approach the complainant. You cannot come within 100 meters of the complainant. If you do come in within 100 meters, then you need to, move yourself out of her space. Those are the things you need to really think about: interaction, presence, and proximity. And I want to emphasize again that I think it's important to talk about with both complainants and respondents about what is reasonable and justified or reasonable and appropriate in the circumstances. I want to talk for a minute about mutual non-contact orders, because I think that there is, in some quarters, a belief that a mutual non-contact order is what's fair. And here I would just want to note that the Association of Title IX Administrators in the United States has issued a position statement opposing mutual non-contact orders unless a victim or survivor, that's their language, specifically wishes to be restricted or the conflict is coming from all parties. So why does it take the position that mutual non-contact orders should be avoided? They say that, first of all, an institution has to be willing to sanction a complainant for violating the terms of a non-contact order if they make a mutual non-contact order, and they say taking such action will be viewed and in fact will be seen as a retaliatory action. They have to be willing to sanction if they're going to put those in place. They also ask the question, why would you restrict someone who is engaged in no alleged wrongdoing? And they're concerned that the terms of a mutual non-contact order could compound the discriminatory effects of the underlying misconduct. So they are opposed to mutual non-contact orders, as I said, unless the complainant specifically wishes to be restricted or the conflict is coming from both parties. Joanna.
Okay. Just briefly, what form should the decision take when the decision has been made to impose interim measures? It should be in writing in some form, although it doesn't have to be lengthy. And both the respondent and complainant should be notified. there may be others who need to be notified in order to enforce the interim measures, and that information should also be shared with both parties, and how long the measures are in place should also be made clear to both the respondent and the complainant. One quick issue that we wanted to address is sometimes complainants are told, well, these are the interim measures that are imposed, but they're strictly confidential and you can't tell anyone about it. And our view is that complainants should not be under that kind of a gag order in response to receiving information about interim measures, that they should be, of course, cautioned to treat the information with discretion, particularly if there's going to be an investigation, and to preserve the integrity of the investigation. But the complainant ought to be able to share that information with her community of support, and knowing that she can share that information is often essential to her sense of safety and security and her trust in the institution. Sorry, Anuth, we're on the next slide. One factor that institutions often consider is the respondent's privacy, but the respondent's privacy rights do not go so far as to make it impossible for the complainant to tell her circle of support and those necessary that interim measures have been imposed. Lastly, just briefly, we've mentioned that interim measures should be amenable to being changed. Different institutions have different mechanisms for doing that. And because we don't have time to get into the weeds on that, just a flag that there ought to be clear processes for both complainants and respondents to provide new information to the institution, or to make requests, or to review interim measures. Now, I don't know, Karen, do you want me to just, there's one question that goes to that, and it's one of the hardest.
Sure, go ahead. Why don't you go with it?
Okay. So on the chat, a really tough question, a really good question that was asked is essentially how do interim measures work only with a disclosure? If there's no intention of the complainant to pursue an investigation, how is it that, doesn't that imply guilt? And then how is there any opportunity for the respondent to respond or appeal the interim measures? So it's an excellent question. And I think to some extent institutions are figuring this out as they go and developing best practices in response to what works. But I agree with you that if an interim measure is imposed only in response to a disclosure, that there needs to be some reasonable time limit on how long it endures. So that may work better. For example, if it's a disclosure in a student's fourth year when she's graduating in 2 months, than if it's a disclosure in first year vis-a-vis another first year student, and you could be facing interim measures otherwise being in place for 4 years. So there needs to be some creativity and flexibility on the part of institutions to address those different circumstances. And practically, it may be that in some cases where that works best, the respondent does not aggressively resist the interim measure, but says, I can live with not being in that class or not being in that building for the rest of the year, particularly if that means that he may actually avoid having to have a substantive determination made in an investigation. So it will depend on a case-by-case basis, and there would have to be a process for appealing the interim measure, regardless of whether it's initiated under a disclosure or under a report. I use the word appeal generally. I don't think it needs to be a formal appeal process, but there needs to be some process in the policy for a review of an interim measure imposed. Karen, you probably want to add to that.
Yeah, on that point, I would say I also think that the original decision maker could be charged with reviewing the decision. So especially if the decision is made quickly with very little information, and let's say, for example, charges are subsequently laid and there's a bail condition of no contact with the complainant, that might influence what interim measures the institution might want to put in place. So I think that the original decision maker should have the ability to review an interim measures decision if there are changed circumstances or new circumstances or circumstances they were unaware of at the time they made the decision.
Great, thank you, Karen and Joanna. I can see that we have a few other questions in the chat box and the Q&A box. So now I'd like to invite our attendees to just share any questions and comments. And again, you can do so by typing into the Q&A box at the bottom of the screen.
So we have a lot of questions. Anuth, why don't you decide which ones we should answer?
Sure, so we can take the first one. So are there any downsides to framing complainant needs entirely through a trauma-informed approach? Should we also be considering complainant needs as a matter of human rights?
So I think I tried to answer that one earlier, but Karen didn't have a chance to jump in. So Karen, do you want to add to what I said earlier?
It's a good question. I mean, obviously, and we haven't framed this presentation so much this way, but obviously you want to ensure that all decisions that are made under sexual violence policies are free from bias and discriminatory thinking. And that's why, for example, a human rights framework that would require that. But one of the things I really think is important, and I want to underscore, and most people on this call would know this, but it's really important to underscore it, is that the decisions have to be trauma informed. One of the things that Joanna and I have seen in some of the work we've done with administrators is they don't understand why a complainant is coming forward 6 or 8 months later and making a complaint and saying, you know, something needs to be done because this is untenable. An expectation of many decision makers who are unaware of the trauma of a sexual assault believe that, you know, interim measures are something that should be sought within days of the events giving rise to the allegations. What we know happens with survivors is often, you know, they have a meltdown 6 or 8 months after the events, and that's the time at which they require interim measures to be put in place. So that's one of the things that's really important in this context around having a trauma-informed response, is an understanding that you know, the need for measures, it doesn't diminish necessarily with time.
Great, thank you. And Karen and Joanna, in your opinion, should interim measures be available not only when a formal complaint has been filed, but also when a disclosure has been made?
I think we dealt with that in the presentation. It's our view that that's something certainly that should be considered, and a few institutions are doing it. So it'd be interesting to look at how well that's working at those institutions. You know, so you know, if that's what a complainant needs, and if a respondent is amenable to that, especially if the respondent it means the respondent can avoid a formal investigation, then it might be what works best for the parties.
Thank you. And our next question is, some institutions have guidelines governing interim measures rather than including details in institutional sexual violence policies. So is the use of guidelines regarding interim measures an acceptable alternative to detailed policy provisions?
Do you want to answer that, Joanna, or should I?
No, you should.
Okay. I mean, there are advantages and disadvantages both ways. You know, some institutions have all of the details in a guideline document. The guideline document, generally speaking, is not approved by the Board of Governors, and it doesn't go through a consultation process, but it's better than nothing. So if the policy itself has very thin or general provisions on interim measures, then a guidance document is appropriate. Guidance documents need to be available, though, so that people know what interim measures are available under what conditions, what limitations, and what processes. So I'm kind of agnostic on whether or not it must be in a policy or whether or not it's better to have flexibility in a guidance document. What I'm concerned about is the number of policies where there's almost nothing either in a guidance document or in a policy itself.
I'm jumping in to just say, to address one of the last comments on the chat, which is, so Karen and I yesterday did this presentation and it took us an hour and a half. So we've been rushing a bit, and maybe it's clear skipping a few things that needed to be said. So one chat comment was that we've been referring to complainants as she and respondents as he, which is both making assumptions about sexual violence, and generally we do acknowledge that persons who are women or identify as women are much more likely to be targeted for sexual violence, and persons who are male or identify as male are much more likely to be the perpetrators. But we didn't do an acknowledgement at the outset of challenges around language and non-binary identities.
Okay, thank you, Joanna. So our next question is, how should situations be managed where there are restrictions imposed on where a respondent can be, and they violate it, but it doesn't affect the complainant? So it's reported by someone else, and so the complainant wasn't, let's say, aware of the breach. Should we then notify the complainant in these cases, and to what extent?
I think that's difficult. One of the institutions we worked with was really clear that there needed to be support for respondents. So respondents understood the terms of an order, and they understood how they were to comply with an order, and understood how to change an order. And it's actually pretty easy to violate orders, proximity orders or interactions or presence orders. And it shouldn't be the case that every violation automatically results in disciplinary action. There's got to be some flexibility and some give for, accidental interaction. So I think one of the things that needs to be in place for respondents is a resource for them to be able to use, to figure out how it is that they comply with the orders.
Great, thank you.
Another question that we have that Karen, both of us maybe want to answer is, so there's a question about, is it best practice to have the same interim measures imposed on both the complainant and respondent? And why doesn't this occur, e.g. harsher measures for respondents? So Karen, you addressed that a bit in your discussion of the ATICSA position, which is that no contact orders should not be mutual. But I think it's important to take a step back and remember that the move towards strengthening sexual violence policies on campus is in response to a massive social problem of violence against women and persons who identify as women, not just in society at large, which is the case, but specifically on university and college campuses. And that as a result of that, there's rates of impact on women and persons who identify as women in dropping out, their grades being affected, their careers and their lives being very, very significantly affected. And so in the context of a discussion of interim measures and as a matter of human rights and recognizing this serious systemic social problem, what's being proposed is remembering to focus on the complainant who's come forward and her needs and right to continue to access education if it's a student, and that the interim measures, which need to be balanced and appropriate and justified in the circumstances, can start with her need to continue going to class. And if, for example, in order to do that, the respondent is moved to a different class or a different time, for example, that's not a harsh consequence on him. It's an appropriate and fair and justified measure in order to ensure that both parties, but with an initial focus in response to the complainant's report or disclosure, that she can actually continue to get an education and finish her degree.
This also underscores again the reason why it's really important to speak to both complainants and respondents, because you might find that a complainant, for example, would rather change residence rather than have him change residence. So, if you talk to her, she might say, I'm happy to move, I'm happy to move. You might also find out that she doesn't mind him being in the class with her. She just doesn't want him coming, half an hour earlier and staying half an hour afterwards, or sitting beside her, or sitting in her view range or something like that. So, but by talking to her, you can find that out. So that just really underscores the need to talk to the parties about what it is that they require in the circumstances. The other thing we should mention is that interim measures are different from accommodation, and it's my view, although I could be dislodged from this view, that a respondent who is subject to interim measures might need to be accommodated. In the same way as someone who was, well, of course, in the current environment, nobody can go to campus. But if you were undergoing cancer treatments, for example, and there would be an expectation that your program would be modified so you could do as much work as possible from home in a safe environment of of home. And in my view, in the event that interim measures are imposed on a respondent, there should be some measure of accommodation where possible to ensure that his education is not compromised, or is compromised as little as possible.
Great, thank you so very much, Karen and Joanna. Just not on time, as I want to honor our 1 hour commitment today. Thank you again for sharing your time and your expertise with us. We've learned a ton, and the recording for everyone who's asking will be available on our website along with the transcript in a few days. So thank you to all of our participants today for joining us and sharing with us. We really appreciate and take inspiration from your commitment to addressing and preventing gender-based violence on your campus, and we all feel very lucky to be able to work alongside each and every one of you. So thank you, everyone. And a kind reminder to please complete the evaluation forms, and we look forward to seeing you at the next webinar in May.